Republican Show Direct Line with Mark Unkelfer and guest co-host Marcus Alzona. Welcome. Take it away, Mark.
Well, thank you very much and welcome to the show. And we're going to we're going to speak with the president of the Free State Foundation, Randy May, who is a Montgomery County resident, but he's also very, very well known in the world of telecommunications policy and law. The Free State Foundation has done a lot of work in this area on a whole range of issues. And so the topic that usually is, how shall I say, something that communications wonks love to talk about, the ins and outs of net neutrality we were just talking about, really has surfaced with this issue of the role or the censorship that's going on with the tech industry and the allegations that tech industry has been unfairly using its unique position. So let's start out with that. And why don't we describe a little bit about some of the legal issues? And you could probably explain, we could probably start with this Section 230 protection that they have, and this issue, this distinction between, on one hand, being a publisher, and on the other hand, being protected as not being an editor. Randy?
Well, thanks, Mark. First of all, thanks for having me. I'm glad to be with you this evening. And, obviously now this topic of censorship online, free speech is on the top of many people's minds, uppermost in many people's minds, and even Section 230. I mean, it's amazing how many people now would actually associate that section with, a piece of legislation and understand what it means, or at least somewhat about what it means. So, right. But here's basically, in essence, what Section 230 says, and it passed in 1996. So, it's good to keep in mind that it was part of the Telecommunications Act of 1996, a major piece of legislation, this was at the dawn of the internet age, if we want to call it that, and that's useful to keep in mind. And what Section 230 says is that if a platform, and when I refer to platforms now, I'm going to be talking about Google and Facebook and Twitter and so forth. Sometimes, I may say big tech, but you'll know we're talking about these platforms. And so Section 230 says if I post something to Facebook, and let's assume Facebook doesn't alter what I post, then Facebook is not to be treated as a speaker or publisher. It's immune from being considered a speaker or publisher. So that would be distinct from a newspaper, for example, or a broadcaster that says something and can be held responsible for and held liable for that speech. Now, so that's one part of Section 230. And then the other part of 230 that's in controversy is Section 230B. The first part was 230A. Section 230B basically says, in essence, that the platform can modify or delete post if it acts in good faith. Those are words that are in the statute. But if the speech is filthy, obscene, lascivious, a few other things, or otherwise objectionable as well. Right. So that's what that does, and it gives them immunity for taking those actions. So in other words, we would think of that as moderating the content. So, that's what Section 230 does.
So it's kind of a halfway measure, this protection that they have. On one hand, you don't think of the phone company as being responsible for how they're being used. You have a conversation, they're in effect a conduit. So the tech companies in some respects have protection like that. On the other hand, they also have components of an editor. There's, as you described, there are some certain circumstances in which they can exercise some control over what goes over. Now, the allegation has been that this has given them the best of both worlds. They kind of have it either way. They're protected against claims, but on the other hand, they can also make, they can also, basically edit or censor. Is that right? And is that a fair way to characterize that?
Yeah, I mean, that's a fair way to characterize the claim, and obviously to try and figure out what to do about it if we perceive it as a problem. And
right.
Let's just put this on the table. I thought the way that the platform companies handled the New York Post story about Hunter Biden, in my view, was wrong and objectionable in my view. They, as we all know, they essentially either deleted the story or relegated it to a secondary status, and we're aware of that. Now, at the end of the day, some people would say that the New York Post the story got more publicity than it otherwise would have, but be that as it may, the platforms took action, which I think was wrong. But here's the thing, then the question is, well, what do you do about it? And here's the way we need to think about it initially. These companies are not now considered utilities or common carriers, as you referred to, like Ma Bell used to be. They're private companies, and in my view, they have a First Amendment right to decide to either accept posts as they wish, or to moderate those posts and take them down under the First Amendment. What I don't agree with, and there are a lot of people that make this contention among the supporters of the big tech platforms, is that nothing should be done to their immunity, that they have, some people even suggest they have a First Amendment right to this immunity from suit. Well, I don't think that's correct either. In other words, in 1996, when Congress adopted Section 230, and I was there at the time, involved, not closely with this issue, but no one asserts that Congress was compelled to grant immunity from lawsuits in Section 230. So I think that the immunity, I'm not one that believes that you cannot ever, that it's not worth examining whether 230 could be modified in some way. It's not one of the 10 commandments that's etched in stone. Most congressional laws shouldn't be considered like that. And this is 25 years later. Again, it's worth remembering there was a rationale, and I think a sound rationale when it was adopted for it to be written that way. And that was that these platforms were just getting started. There had been some cases decided that treated them as common carriers. The cases were divided, and Section 230 resolved that issue by saying you're not a common carrier. But now, 25 years later, I doubt if there were many congressmen and women at the time that envisioned Google, Facebook, of course, and so forth, and with all the power that they have. So it's worth looking at whether there should be changes or could be changes to Section 230.
But you touch on one of the conundrums, which is that, of course, they are private entities. And so some of the suggestions or proposals that would, in effect, regulate speech or make requirements of them have the effect of impacting their private entities. First Amendment applies to government. So you're in picking winners and losers. So we've talked about, I think in the past in your writing, you've talked about some of the other approaches, alternatives. You've obviously been open to some changes at 230, but you've also suggested another approach is to take antitrust. How would that work?
Yeah, no, I think that that's worth looking at, and I'm increasingly of the mind that that may be a way to get at this issue in a way that doesn't leave them with so much power. And let's just put it on the table. I mean, I've said this I said it on C-SPAN within the past week. I'm someone with a perspective that is free market, right of center, conservative. And in my view, these companies and their actions evidence a left-leaning, left-wing bias. But I understand others don't see it that way. But I see it that way. But I think the way to get at it, Mark, may be through looking at whether there might be an antitrust remedy, and that possibly could be breaking up the companies, perhaps. And I'm not here suggesting I've really arrived at that conclusion, but I think there are lawsuits right now that are looking at that, and it's going to be examined. Another antitrust type of claim might be that they're possibly have conspired in some way to keep out the competition, keep out other companies from emerging that would have different views about how moderation should work. They would have different standards, perhaps. I began to think about that, I think, more seriously in light of what happened to Parler when, as we all know, Parler was almost overnight, I think, or certainly within a 48-hour period, Parler was blacked out completely, wiped out from the face of the internet, we might say. And in order for that to happen, you had Twitter, well, not Twitter directly in that case. Twitter would be the beneficiary of Parler's demise, but you had Google and Amazon and Apple, three pretty substantial companies with a lot of market power, all take actions that had the effect of making it difficult, if not impossible, for Parler to continue in business. And it turned out, at least on a temporary basis, it was impossible. So that's a way of saying that the way it happened makes one wonder whether, at least it's worth the authorities looking at whether there was some type of, under the antitrust laws, of course, you're not allowed to collude in certain ways that injure competitors. So that's one thing. I think, if we're taking a step back to think about it, I think, that's a way of saying that, in my view, a solution to the dilemma of this situation is trying to get some more competitors into this space. And then you would have competition among those different firms, again, for whether, maybe it's not against the law to have a leftward bias or a right-wing bias. I mean, that's the way a democracy works. And that's what our First Amendment protects. But if we had, some more competition in the space, I think that would be a good thing. It's not easy to get there because of the phenomenon, as you know, that we call network effects. People want to aggregate so that their reach among their friends and so forth is extended. But that's one thing that should be looked at.
So there is antitrust litigation pending, and the states have initiated, but that is separate. That is focused on sort of the advertising market. That has not. There hasn't been a claim yet that addresses this big, because it's a relatively recent development, and the advertising claims have been percolating for a while.
Parler actually did file a lawsuit, and I think it might have been in the state of Washington. I forget, but I think it was dismissed by the district judge, and I'm not sure whether they appealed or what's happened, but they filed a claim along the lines that I was suggesting.
Right.
I think.
Okay. And that would be one of the questions is this notion, and this may be something we can talk about. Some of the other issues is in effect the Apple and Google, which operate the app stores, if you will, basically are mandating a particular business model for these kind of a micro blogging site like Parler, which is to have some kind of intermediary who does some filtering. And presumably there may be other ways we've talked about which would allow for that. I think I interrupted you, Marcus. I'll maybe give you a chance to.
No, I mean, the situation where it's been okay from, if you step back at a higher level, if you're being censored on one site, the rationale, the free market is that, okay, well, you can go build your own app, you build your own social network. However, then immediately the client stores, the two dominant operating system, the mobile operating system, iOS, the Apple App Store, and the Google Play Store, they end up banning it. Well, okay, well then you can make a web app, and then AWS bans them from the platform. And in doing so, I believe either them or another company essentially caused a data breach, because the verification system that they use to verify accounts no longer, it was taken down by their service provider, and therefore people figured out that you could get into any account without the text message verification, and then which caused a number of data breaches on there. It seems like the system as constructed, not as envisioned back in the 90s, but it's evolved to a point where even if the large companies aren't directly colluding, the system in itself, it's almost seems like it's structured such that with enough people, you can mass report a company, and force that entity to deplatform any thought that's not in of a certain angle that agrees with most of the people who work in Silicon Valley. So when that happens, they tend to be, oh, okay, well, what can I do? My hands are tied. This is a mass report. But if it's on the other side, if it's they immediately stop and reconsider. So I guess I'm concerned. Is the system broken as it is? But regardless, though, is the issue of a platform versus a publisher, how does that rate as far as a way to solve this problem?
Well, that's an interesting question, and there have been suggestions. There was just a op-ed, actually, I would refer our listeners to, that was in the Wall Street Journal just a couple of days ago. It was written by Philip Hamburger, who is a law professor at Columbia, I think, and he was suggesting that it's worth thinking about. I don't think he came down definitively on this point, but he suggested, and others have said, that the provision of immunity in 230 is sufficient to convert the platforms to government actors. You see, under the First Amendment, if they're the government, they would be in a different status than they are now. And I don't think there are many cases that exist, and he didn't cite any. I don't believe, that have. Well, and there, we haven't had comparable situations, but where where the conferral of immunity, the legal immunity, is tantamount to making them the government. So that's relevant, because if they are the government, then the government has to be viewpoint neutral under the First Amendment. That's a core principle of the First Amendment. and therefore one could bring claims when one doesn't think that they're being viewpoint neutral. I'm not convinced that's the way to go, and I actually appreciate everything you said and the way you put it. But the problem is, I think what we have to keep in mind, at least I try to do this as a conservative and free market, rule of law oriented person, is that this may be a case where a lot of the cures are worse than the disease, in the sense that when you get the government involved, whether it's overseeing Apple's App Store or making determinations about the platform speech, and I'm going to suggest some ways they could be involved, perhaps in a minute, but it's always, to me, it's a little tricky when you want to get the government involved. Not a little, I'd say a lot, tricky when you want the government getting involved in making speech decisions. I had a piece published in the Washington Times about 3 weeks ago now, and what prompted it was there was a proposal by 8 Democratic congressmen and women in late December. This proposal got very little notice, but essentially they wanted to create a new cross-agency government unit. It was called the Digital Democracy Task Force or something like that. And when you cut through all of it, Marcus, what the task force would be tasked with doing would be to give some guidance. They wouldn't necessarily take individual cases, but they would give guidance that others should follow as to what constitutes misinformation and disinformation. Now, we hear those. There is clearly, I don't want to be misunderstood, I think there is disinformation, there is misinformation, but you know what? My definition of what constitutes disinformation or misinformation is not always going to be the same as someone else's. But be that as it may, I'm wary of the government making those decisions. So a lot of the things that we talk about in trying to resolve this, that go down the regulatory route, in one way or another, may lead to the government being involved in arbitrating, the truth or falsity of speech. So we got to be concerned about that. One thing that, one thing that possibly could look at, but again, a lot of this doesn't get, because most of the objections go to just pure speech, not if we were talking about something that's illegal, like child pornography or posting ads about illegal drugs, or something like that. It's in an area that we don't call, pure. It's not certainly political speech, and those things may be illegal, but political speech is different. But you could potentially require the companies to be more transparent about their policy, provide more detail than even they provide now. Most of their terms of service, they can be lengthy, and most of us, we don't want to read them. But when you do read them, a lot of the actions that are taken that most people are concerned about are taken under the particular term of service that refers to harmful speech. That's what you often see. But maybe there could be a requirement that their algorithms be possibly more fully disclosed. I'm not totally comfortable with all these things at this point, but more transparency in how they are making these decisions. And then if they don't abide by their more transparent terms of service, then maybe you go to the FTC, to take action. I'm not enamored of private citizens, private people being able to file claims necessarily themselves and have the trial lawyers make this a whole new line of work. But maybe the Federal Trade Commission Good.
So Section 5, unfair and deceptive trade practice, has been the club in the closet, if you will, for privacy terms of the service. So,
Right.
but I think as you've described that there's the current language, there's more than enough wiggle room that what's being done is probably not a violation because they've lifted them. It's interesting. Governor DeSantis, Ron DeSantis of Florida, has done a proposal in this area that he released, I think, yesterday or the day before. In that, this is one of the areas. Now, it's done, obviously, he's a governor, so it's at the state level, which raises some issues. But it is to require more transparency about what the process is, what the algorithms, basically what the processes are. It also would mandate some kind of opt-out process. So a little like with your search function where you can, have safe search or unfiltered search, and you can make your own choice as to what you would want to do. I think the idea would be to allow for that policy for individuals to exercise their own policy as to whether they wanted the content to be screened. I'm not sure about doing that from the state level. We could talk about that. It does seem that it would be something that the tech companies would, if they were smart, might want to embrace.
Yeah, it sure seems like it would be something that perhaps just, under the best practices rubric. I think, Mark, you raise a very good point that, hopefully we might see them more seriously begin to consider things that would diffuse the situation in ways that make sense. And they're not just cosmetic. And that's when I'll just add my voice to what you said about not doing this at the state level. Really, I've argued for a long time that both the internet service providers and I think this would be true to a large extent of the platforms, they have to operate really on a national, international basis. We can't control what China or Russia does, but I think in terms
or France
or yes, exactly. Exactly. But we do have a commerce clause in the Constitution. I'd prefer to see national solutions, just in terms of not unnecessarily. I don't think the objective is to try and unnecessarily burden them, with things that are not practical, but to find practical solutions to the problem.
So that is one approach. So antitrust is perhaps one approach, a voluntary approach of allowing for more user control, which actually goes back to the way the privacy processes developed over time, which was to allow users to have more say, and those were features that were incorporated into browsers and really have diffused, I think, a fair amount of the pushback on privacy policies.
Yeah, no, I think that's right. Just thinking, again, going back to 230 for just a moment, I don't mean to keep going back, but we at the outset, we talked about that language in 230B that talks about removing content that's otherwise objectionable. It might be that, and of course, when you try and constrain that too much, you run into this First Amendment thing where you don't want the government directing it. But maybe Congress could just direct that there be somehow referred to the transparency and the consistency that would find the words to require them to do more without telling them to do it, and then it would become a Federal Trade Commission issue as to how they're doing it, just like the Federal Trade Commission makes decisions about unfair practices and so forth.
Well, when Section 230 was passed, it was really, at the start of, well, it was actually in the first .com bubble, but which I participated in. But the startup community, the argument is the startup community, the early internet community really needed this to get its feet off the ground. You're no longer talking. You're talking about the largest companies in the world. They don't need to this exemption necessarily to get their feet off the ground. Or
Right.
maybe to put it another way, why would these large tech companies need this exemption and not just be treated like the New York Post? Just if they're not a platform that just is a more common carrier, then just treat them like a publisher and not impose any additional government regulation. Just say you have the same regulation as other companies.
Yeah, and in effect, what you would be saying, Marcus, would be that they have the same duty of care. They would have a duty of care obligation like a newspaper does. And of course, sometimes the New York Times v. Sullivan case is brought up. That's the one in which the Supreme Court in I think it was 1964, held that the New York Times and other papers would not be liable for defamation unless they recklessly and knowingly, printed something with regard to public figures. What I'm trying to say is that that was directed at, at a public figure, but and so that was an immunity, and sometimes these platforms hold that up, but that was created not by Congress, but that was a judicial doctrine created by the Supreme Court as a matter of defamation law under the First Amendment to make the defamation law consistent with the First Amendment. One way, to do that, what you suggested, Marcus, that may be worth thinking about is whether you could, let's just assume perhaps you wanted to retain 230 as it is, but you exempted from the immunity or remove the immunity for firms that whose revenues were above $1 gazillion or whatever Amazon is or Google, and
GameStop.
Because
Okay.
their whole argument, is based on, the burden, of course, and the litigation cost that they would bear, but they do have a lot of resources. But one reason that makes me think of that, and not totally, tongue in cheek, is that Google, as I said recently, I think, and they used to say this in the net neutrality context when they were opposing net neutrality. And I know people on different sides of that issue, but Google would always say that we're not concerned about, this net neutrality thing that people are trying to impose for ourselves, but we're concerned about the little guy, we're concerned about the next startup. That was the formula, actually, that we're concerned about the next startup. Whenever someone in Washington is telling you that they're not concerned about themselves, about something that's coming, but they're concerned about the next guy, then something's up. And the same thing, and they've actually heard that here, that we could probably, I think it was Google, that we could probably, live with having some of this immunity removed. But what about the next Google? Well, that goes to your point, Marcus, about maybe there's a way. I wouldn't necessarily totally remove it, you don't have to necessarily think about it that way, but maybe you put some type of cutoff point for, the Amazons and Facebooks of the world.
Well, that'll keep them scrambling. I know we're up at, we were going to keep this to a half hour. I wanted to thank you. Is there anything we should be looking for from the Free State Foundation that you guys have coming up soon?
Well, one thing we have coming up soon is we've got the maiden speech for the new FCC Commissioner, Nathan Symington. He'll be giving his first speech. You can find a link on our website, freestatefoundation.org. This will be actually the third FCC commissioner that's decided to give his or her maiden speech with the Free State Foundation. So we always feel honored by that. Mark, the other thing I'll say is that it is almost certain that the net neutrality battle will be coming back, with the switch in administration. This is ping pong back and forth now over several administrations. It's essentially, when you get right down to it, a battle over whether the internet service providers are going to be going to be regulated more or less like public utilities or not, or whether they're going to have more flexibility. And that's a subject that I've been involved with for about 15 or 16 years now. So that'll be coming up, and maybe when it does, if it's something that's of interest, we can talk about that. And of course, their relationships, which we, at that time we could talk about sort of how that's the other side of the coin, or in some ways the same side of the coin, concerning this. So that's something to watch out for.
I look forward to discussing that. We all got documents that we have stored away that just simply keep coming back again and again. Yes,
Mark, that prompted me to.
Yes.
I guess it can be saying this is a book we put together called A Reader on Net Neutrality and Restoring Internet Freedom. It's called A Reader because we didn't sit down and write, the whole manuscript again. It's a compilation of things that we had written over the years, and Free State Foundation affiliated scholars have written. So the next time we're in that battle, we pretty much have it right here, ready to go with it.
Well, we will be discussing. Unfortunately, we're going to be discussing that again, but we'll look forward to having you back to get into it in more detail. But thank you for taking this whole issue up of tech industry censorship, and thank you for coming.
Thank you.